2022. All defendants, I want to advise you of your rights. When I ask you if you understand your rights, this is what I'm referring to. You have an absolute right to remain silent. Anything you say can and will be used against you. You also have the right to an attorney at this proceeding. All participants, this is being broadcast over the internet as a live stream. It's also being recorded. That means any member of the public can log on and watch this. Those who receive a signature bond will be reset per the notice. Ms. Bridgewater, what is my SAP reset date? Is it the 3rd?
No, ma'am, it is the 5th.
All right. Those who receive a surety or a cash bond today will be reset to the state all-purpose calendar on January the 5th, whereby bond and other issues can be revisited at that time. All right, who do we have first?
Good afternoon, Judge. It's going to be position 1, Cooper.
All right, good afternoon, Mr. Cooper. Your case is 22 CR 0084445E. In this case, you're charged with driving with defective or no headlights, driving while your license was suspended, DUI, less safe, giving false information, and open container, each with the offense date of the 21st of December. You understand your rights?
Yes.
All right, Mr. Howard.
We got 8 total between Georgia, Tennessee, and Delaware. And New Jersey too. 2009 New Jersey money laundering conviction. Last arrest in Delaware was in the year 2000. Probation. Last arrest in Georgia was back in March. Possession of a Schedule 1 controlled substance, sale of marijuana, and misdemeanor obstruction. He's out on pretrial for one of those charges. 2016 suspended license, that was dismissed. Let me see about Tennessee real quick. That was 2011 reckless driving conviction out of Tennessee. 2014 driving on revoked license. That's it.
All right, thank you. Ms. Sowery, is this your case?
Yes, Your Honor, it is.
All right, please proceed.
This incident took place on Piedmont Road in Atlanta. While patrolling the area, an officer observed a vehicle that was driven by the defendant operating without any headlights. A stop was initiated and the defendant was asked for his license, but stated he lost it. And he started to fumble through his phone to look for a picture of his ID. The defendant was asked for his name and date of birth several times, but he ignored the officer. The defendant was then asked to step out of the vehicle, which he did. And when he did exit the vehicle, he almost lost his balance. The defendant did admit to coming from a club and consuming 3 to 4 beverages of alcohol 45 minutes prior to the stop. He also displayed slurred speech, an odor of alcohol on his breath, and glossy eyes. The defendant gave the officer a false name of Joey Calloway, and a search incident to arrest revealed that there were 3 open containers of liquor bottles in his vehicle. And of course, once he was fingerprinted, his true identity was revealed. Your Honor, I have additional history regarding the defendant's driving record. In 2017, he had a failure to obey a stop sign. That was a NOLO. 2017 FTA, 2017 suspension for failing to appear. And in 2014, he also had a suspension of his license for failing to appear for a citation. I also did have that open possession of a Schedule 1 obstruction and possession of other drugs case that is currently open. As such, Your Honor, he does present a risk of reoffending, and he does have history spread out in multiple states. The state's recommendation is a $7,500 surety bond. That's $3,000 on the DUI, $1,500 on the open container, and $1,000 on the remaining counts. No driving without a valid license, and no drugs, alcohol, or weapons.
All right. Thank you, Ms. Sowery. Ms. Gamp.
Good afternoon, Your Honor. Mr. Keenan Cooper is 46 years old. He has been in the Atlanta, Georgia area for 20 years. He is married and has been so for 20 years. He has 2 children and a 17-year-old, and he also has a special needs child, Your Honor. He states that he is the primary caregiver. He stays at home to care for this child while his wife works. Mr. Cooper completed high school. He has 1 year of college. He studied business administration. He is currently employed at Tribeca and Opium. He denies the allegations. He's presumed innocent in this and any open cases. I am requesting a signature bond on Mr. Cooper's behalf. If Your Honor determines that he's ineligible, then I would ask for a more reasonable bond, a bond of no more than $1,500, and that's a split bond, Your Honor. I would ask for a signature bond for the equipment violation, a $500 surety bond. Let me back up. Equipment violation, signature bond. Driving license suspended, $500 surety. DUI less safe, $1,000 surety, and a signature bond for the remaining giving false information and possession of an alcohol container, Your Honor. Thank you.
All right, thank you. Give me one moment. All right, defendant's going to receive a $4,000 surety bond broken down as follows. $250 surety on the effective equipment, $500 on driving while the license was suspended or revoked, $2,000 on the DUI, $250 on the false information, and $1,000 for the open container. If my math is correct, that should equal the $4,000 surety. He's not to drive unless he has a valid license issued by the Georgia DDS, and he is to have no alcohol, drugs, or weapons as a condition. Is there anything further?
Nothing from the defense. Thank you, Your Honor.
Nothing further from the state.
All right, best of luck to you, Mr. Cooper. Who do we have next?
Position number 5, courtroom number 3.
Has courtroom 3 heard their rights?
Yes, Judge.
Thank you. All right, good afternoon. Are you Dana Hagwood?
Yes, Your Honor.
All right, your case is 22 CR 0084443B. In this case, you charged with battery family violence with the offense date of December the 20th. Do you understand your rights?
Yes, ma'am.
All right. Mr. Howard, can I have the history, please?
6 total. Last arrest was November 2021 out of Dinwiddie. Possession of a Schedule 2, misdemeanor possession of marijuana, felony shoplifting, 2 counts of contributing to delinquency of a minor. Those are open out of DeKalb County. February 2021, DUI, misdemeanor possession of marijuana, endangering a child by driving under the influence. 2018 FTA for shoplifting. Came off a 2016 arrest that was later dismissed in 2018. Carrying a weapon within the school safety zone, 2011. That was NOD.
All right, thank you. Ms. Soury?
Yes, Your Honor. This incident took place at 706 Cedar Avenue in Atlanta. The victim in this case, his name is Keshawn, that's Kashawn, last name Freeman. The victim stated that this defendant, she was the one who actually called the police, but she was the person fighting him. She called the police to try to get him arrested instead. The victim told officers that there was an argument that happened between the two when he took her phone and went outside. And while outside, the defendant was grabbing and biting the victim. He did sustain a large scratch on his chest and bite marks on his arm and neck. As such, the defendant was identified as the primary aggressor, and she was arrested, not the victim. As we've heard from pretrial, this defendant I have 2 open cases, one from 2021, which is a DUI, possession of marijuana, endangering the child. That's open in Clayton. And then the theft by shoplifting, possession of marijuana, contributing to the delinquency of a minor, that's open in DeKalb, and that's actually a felony. She does have a 2018 FTA and a carrying a weapon within a school zone that was eventually null-prossed in 2015. The state's recommendation in this case is a $4,000 surety bond, a stay away, no contact with the victim, as our office did speak with him and he does not want contact, 1 day anger awareness, and no drugs, alcohol, or weapons.
All right, thank you. I'm gonna sound for Mr. Freeman first, and then we'll go to Ms. McLeod. Mr. Freeman, if you're on this Zoom conference and wish to be heard, this is your opportunity to speak. I don't see that name on the Zoom conference, so we'll go to you, Ms. McLeod.
Good afternoon, Your Honor.
Good afternoon.
My client is 29 years old. She is the mother of 3 minor children, 9, 11, and 7. I believe their ages are, Your Honor, and she is their primary caretaker. She is employed. She works in a restaurant. She tells me, Your Honor, that she has been the victim of domestic violence by the alleged victim on several occasions. Most recently, he punched her in the eye. As the prosecutor said, my client was the one who called the police. She called the police because she was trying to leave Mr. Freeman's home and he would not allow her to leave. He took her phone and he was holding on to her, preventing her from leaving. So she was merely struggling with him in order to get away. And she called the police, hoping that she would get assistance in this. And they arrested her, Your Honor, when in fact, she really was the victim and she was the one who had been asking for help. Her history shows, Your Honor, even though she's been arrested a few times, she has no violent convictions and she has not been arrested for anything violent. I would ask the court to give her a signature bond so she can go home to be with her children, Your Honor. Nothing
All right.
further.
And Your
Thank
Honor, I
you.
do apologize. The victim actually informed our office that he wanted contact with her because she's pregnant, but does not want her back at their residence. But the state would still ask for no contact regarding this incident.
My client doesn't want any contact with him because he's abusive, Your Honor.
All right, thank you.
And she plans to get a restraining order against him. She wants no contact.
All right, thank you. Are any of the children his did the
No,
victim?
Your Honor.
They don't
The
share any
children are not
children.
his children.
Those are not his children. All right, thank you. All right, at this time, the defendant is going to receive a $2,000 surety bond. She is to have no contact with the alleged victim in this case and stay away from the address on Cedar Avenue. If she has any items there, she can return one time with a member of law enforcement to get any of those items, and she's to have no alcohol, drugs, or weapons. Is there anything further?
Nothing further from the state, Your Honor.
All right, best of luck to you, Ms. Hagwood. Who do we have next?
Position A, Keshi.
All right, good afternoon, Mr. Keshi. Your case number is 22 CR 008450C. In this case, you're charged with battery with the offense date of December the 21st of 2022. Do you understand your rights?
Yes.
All right, Mr. Howard.
His 9th adult arrest. He got history out of Texas and California. That California history is juvie, also Florida too. 2010 arrest in Florida for reckless driving. Last arrest in Georgia was 2019, simple battery, family violence. 2018 DUI, it was amended to reckless driving conviction. 2012 suspended license. Another 2012 suspended license, NOD. 2012 obstruction, misdemeanor. Reckless conduct, suspended license. And interfering with property of public utility company. Hold on, man. 2010 misdemeanor possession of marijuana. 2010 suspended license. Let's see. I think that's it.
Okay.
Hold on,
Thank you.
Judge. Hold on one more.
All right.
I was looking for the Texas history. Maybe that's not Texas, that's Florida. Yeah, that's Florida, not Texas.
That's what I have as well.
Yeah, I misspoke on that one. That's all though.
Okay, thank you. Ms. Sowery?
Yes, this incident took place at Rock Steady Lounge, and that's located at 907 Marietta Street in Atlanta. The victim in this case, whose name is Sean, that's S-E-A-N, Alexander Carter, he stated that he was at the incident location when he noticed that his female friend was not with him in the section. So the victim went to make sure that his friend was okay. When he got close to the female bathroom, the defendant's girlfriend was standing in front of the victim. The victim stated that he then placed his arm around this person in order to walk past her. When the defendant saw this, he thought that the victim was touching his girlfriend inappropriately, and that's when he punched the victim in the mouth. The victim did sustain a bloody upper lip and scratches behind his ear. Your Honor, I just want to note with that 2019 simple battery family violence case that is currently open, that's against a different victim, of course. However, it's still open because the defendant FTA'd. So he does have a 2022 FTA and presents a risk of flight as well as a risk of reoffending. The state's recommendation in this case is a $5,000 surety bond, no contact with the victim, a stay away, 1-day anger awareness, and no drugs, alcohol, or weapons. And Your Honor, I do believe our victim is on the Zoom call, so if you may sound for him when appropriate.
All right, thank you. I did see Mr. Carter on the line. Mr. Carter, if you wish to make a statement, I'll need you to unmute so I can swear you in. And what I'm most concerned with is whether you wish to have contact with the defendant in this case. Please raise your right hand. Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge and under the penalty of perjury?
Yes, ma'am, I do.
All right, you put your hand down. What would you like to tell the court at this time?
I just want to make a note that some of the information that was stated by some of the legal staff is incorrect. The altercation happened when our mutual friend, Gabby, was me, Gabby, the defendant, and his girlfriend, who alleges that I touched her inappropriately. We were not by the bathroom. We were sitting in the section that our mutual friend had paid for his birthday party, and we were all sitting down. Gabby was intoxicated. She was on my left. The defendant's girlfriend was on my right, and the defendant was on the end of the couch. It's a 4-seater. We were all sitting down. Gabby was intoxicated, and after she came back from the bathroom, she sat down next to me. I checked on her. Her and the defendant's girlfriend were having a conversation. They were asking questions. When I was trying to answer a question for the defendant's girlfriend, I did put my arm around her and I leaned in. Roughly 2 seconds after that, the defendant stands up and punches me in my face twice. After that, that is how the fight ensued. No one was by the bathroom. That all that information is incorrect. And I plan on going by Rocksteady to get the camera footage both inside and outside to show exactly what happened, because there's a lot of information in this case that is, to me, is grossly inaccurate.
Okay.
And Your Honor, this, of course, the state is reading the facts that were alleged in the warrant and given.
I understand.
by the
Yeah, I
officer.
understand.
Thank you, Your
I
Honor.
understand. Yeah, I understand, Ms. Howard. I think I've got a clear picture. I understand the state has done their diligence here. All right, Ms. Kim, would you like to proceed?
Yes, Your Honor. Mr. Cash is actually 44 years old, and we have no objection to stay away and no further contact with Mr. Sean Carter. My client was basically self-defending himself and his girlfriend. Indeed, his girlfriend is filing a warrant. I mean, she's going to file a police report against Mr. Sean Carter for sexual battery to touch her buttock when Mr. Sean Carter was sitting down next to her. My client was not drunken. I mean, my client's girlfriend was not drunken, along with my client as well. It was Gabby who was drunken, but not my client and his girlfriend. So because of that inappropriate touch, he was provoked and my client had to defend himself. So we would like to request for a signature on bond. And yet, if Your Honor is not inclined to give him a signature on bond, we would like to request for the lowest possible bond as much as we can. Mr. Cash has been here in Georgia almost all his life, and he is marketer for his self-employed business. He has been doing that for about 2 years. He has actually bachelor's degree for sociology at Morehouse, and he also has Oh, no, he does not have any more. We would like to request for maximum $1,000 good bond. Thanks, Your Honor.
All right, defendant will receive a $2,500 surety bond. He's to have no contact with the alleged victim, last name Carter, and he's to stay away from the address on Marietta Street, have no alcohol, drugs, or weapons as a condition. Is there anything further?
Nothing further, Your Honor, from defense.
Nothing from the state, Your Honor.
All right, best of luck to you, sir. Who do we have next?
Position 6, Jackson.
All right, good afternoon, Mr. Jackson. Your case is 22 CR 0084449Y. In this case, you're charged with simple battery family violence with the offense date of October the 28th. You understand your right?
Yes, ma'am.
All right, Mr. Howard, can I have the history?
Judge, I don't have that one. Actually got it on the printer.
I show that I have a waiver on that.
That's what I thought too, but I guess he's there.
He's there, so I guess we go forward.
Yes.
Ms. Howard, do you have the history?
Yes, Your Honor. Is this for Mr. Jackson?
Yes.
Yes, I have his history.
Okay, we'll defer to you. Please proceed, Ms. Howard.
The defendant has an open 2021 theft by taking case in our Superior Court. He has a February 2022 simple battery family violence conviction that's against the same victim today. There was a no contact order and a stay away put in place by Judge Morrow. He has a theft by taking open case where you actually, Your Honor, gave him a $10,000 signature bond through the jail, yet here he is again today. He has another simple battery family violence against the same victim where he was issued a no contact and a stay away order. That case is from last month. And I have a 2022 in July, an entering auto theft by taking. Your Honor, the facts of this case is that at 3256 West Manor Lane, Southwest in Atlanta, the victim in this case, whose name is, I think it's Mia, Meyah, last name Jackson. She stated while she was standing inside her bedroom, she felt someone directly behind her. And when she turned around, she saw it was the defendant, who is her son, and he slapped her in the face. The defendant then fled the scene. Your Honor, due to the defendant's constant violence against the same victim, as I've read, he has 3 cases against her, one which he pled guilty for doing the very same act today. The state's recommendation is a $3,000 cash bond, no contact with the victim, a stay away, 1-day anger awareness, and no drugs, alcohol, or weapons.
All right, thank you. Ms. Kim?
Yes, Your Honor. Actually, my client is only 19 years old, and he has been in the facility detention center for about 1.5 months. He's been there from November 6, 2022. This just came up yesterday. However, this date of offense was October 28th, and apparently he has been continuously getting punished in the jail from November 6, 2022 for the same victim, same complaining witness, the battery cases. So I would like you to consider that part. And Mr. Jackson is, of course, he's from Georgia, and he graduated from high school, actually May 2022 this year. He says his GPA was A and B's. He wants to go to college to get a bachelor's degree because he dreams to be a physical therapist. And he is very enjoying his reading. He also played football, but he could not make it to the team. And yet he resides with 3 sisters and grandmother. That's what he's planning to do as soon as he gets out of the jail. Your Honor, we would like to request for low good bond, maximum $1,000, and he has no funds whatsoever to pay for the bond, since his mother is the one who's not paying for the bond. He is qualified for public defender's service because of his no income, and he's been there in jail for like, he cannot find a job in the jail. So we would like to ask for a maximum $1,000 good bond. Thanks.
And Your Honor, I just wanted to state for the record, there are 3 cases, 2 have different case numbers from the case before you today. So I just want to make it clear that this is not one incident. These are multiple charges against this same victim, nothing further.
I'm gonna sound, I did not sound for his mother. Is Mia Jackson on the line and wishes to be heard? All right, hearing and seeing none. At this time, the defendant is gonna receive a $5,000 surety bond. He is to have absolutely no contact with Mia Jackson and stay away from the incident location. Is the incident location alleged to be his mother's home?
Yes, Your Honor.
Yes.
All right, so he must stay away from his mother's home. He is also to have no alcohol, drugs, or weapons as a condition. Is there anything further?
No, nothing further, Your Honor.
Nothing from the state.
All right, best of luck to you, sir. Who do we have next?
Position number 7, courtroom
All
number
right.
3.
All right, good afternoon. Your case number is 22 CR 008451J. In this case, you're charged with theft by taking and contributing to the delinquency of a minor with the offense date of July the 31st. Do you understand your right? Is that a yes? All right. Mr. Howard, can I have the history, please?
Second arrest. Last was 2016 out of Texas. It was for a driving offense.
All right, thank you. Ms. Soury?
Yes, this incident took place at 1034 Huntliff, that's HUNTLIFF Village in Sandy Springs. 2 minors by the initial of JL and NB have been engaging in fighting for a while now. One of the minors is the defendant's daughter, and on the date of this incident, the defendant told both of the minors that if they were going to fight, they would have to fight in front of her. And she also told a different group of minors that they could fight in her presence as well. And after the fight, Your Honor, the defendant and her daughter took one of the minor that's involved in this case, her initial is JL, took her wig and they were filmed dancing with the wig. Your Honor, the state's recommendation is a $3,000 surety bond. That's $1,500 on each count. No contact with minor JL and no drugs, alcohol, or weapons.
Okay. You're not asking to for her not to have contact with her own child, correct?
That's
Ms. Soury?
correct. That's correct, Your Honor. And I'm also asking for a stay away from the incident location if she does not reside there.
Okay, thank you. Ms. Kim?
Yes, Your Honor. Ms. Jahani is actually the one who is wrongly arrested. She was not even around the incident scene at the time. There was another mother of child who was lynching my client's child. She should be the one who should be arrested. However, my client is here in the jail when she is the mother of the basically victim. Your Honor, she has been here in Georgia for about 3 years. She's from South Carolina, and she has been employed at LTS, IT company. She's a nurse, going from different school to take care of different things related to the medical issues. She's been working there for about 1 year, and other medical fields, she worked about 2.5 years. And Your Honor, she went to get associate degree from the college, and she's currently enrolled and pursuing a bachelor's degree from South College as well. She also served in the Army from August 2012 to July 2018, 6 years of serving for the country, discharged with honor, and she did not encourage her children to fight with anybody. She was actually taking a shower at her place when this was going on, and other children came to her because they wanted to let her mom the mother know that two kids were lynching her daughter. She has 3 children, 16, 14, and 7 years old, and she has to go back and take care of them. Your Honor, she resides at 1034 Huntcliffe Village Court, Sandy Spring. That is her place, and we would like to request for a signature on bond, since this is her first offense that is related to any kind of violence, and she is the wrong one who was arrested. That's it, Your Honor. Thanks. Oh, by the way, she's the one who turned herself in when she got an email from the investigating officer that he has arrest warrant. She came to the turn herself in to take care of this matter, to sort this out, and she does not understand why she's actually got the warrant. Thanks.
All right, at this time, defendant will receive a $3,000 signature bond through pretrial services, $1,500 on each charge. She's to have absolutely no contact with the minor, initials JL. And she's to have no alcohol, drugs, or weapons as a condition. I am going to order that she take the 1-day anger awareness course. Is there
Thank
anything
you.
further?
Nothing further, Your Honor.
Nothing
Thank
further
you.
from the state.
All right, best of luck to you. Who do we have next? Who do we have next? I'm sorry if they're announcing it. Courtroom 2, it's muted.
Sorry, Judge, I thought I was unmuted. It's position 13, Porsche Brown.
All right, thank you. All right, good afternoon. Your case number is 22 CR 008454A. In this case, you're charged with battery family violence with the offense date of December the 21st. Do you understand your rights?
Yes, Your Honor.
All right, Mr. Howard.
Second arrest, 2019 DUR. It was
Thank
admitted to reckless driving conviction.
All right, Mr. Walker, this is your case?
I believe so, Your Honor. I'm filling in, so bear with me. But
All
I
right.
do believe it's my case. So give me 1 second.
It's good to see you, Mr. Walker.
Good to see you as well. Happy holidays. So the state's
Happy
recommendation is going to be a $3,500 surety bond, no further contact with the victim, a stay away from the incident location, which is 7,000 Roswell Road, a 1-day anger awareness, no drugs, alcohol, or weapons. In this case, the police were dispatched to a domestic disturbance. Upon arriving at the location, they spoke with the victim, who stated that her live-in boyfriend, his live-in boyfriend had assaulted him. Give me 1 second, I'm reading the warrant. It said that the defendant put him in a chokehold and pushed him against the wall. At that time, the victim did call 911. Law enforcement was dispatched. They interviewed the victim and the defendant was taken into custody on the above listed charges.
All right, what's the victim's name, just so I can sound for the victim?
1 second, I just clicked off the page. Keith Crawford. Is he on?
All right. I'm sounding for Keith Crawford at this time. See if Mr. Crawford would like to make a statement. All right, hearing none, Ms. McLeod.
Yes, Your Honor. My client is 38 years old. He has absolutely no violent history, and the one arrest he previously had was traffic related. My client has an associate's degree, is gainfully employed in the management of rental of buildings. That's what he does. He is, and has done that for some time, Your Honor. He tells me that he was not the aggressor in this unfortunate incident. He is okay with the state's recommendation regarding no further contact between the parties. My client does not want to have any contact with the alleged victim, Your Honor. He is, even though my client's name is the one the only one on the lease of 227, apartment 227 at the 700 Roswell Road location. It's an apartment complex, Your Honor. He is okay with the alleged victim staying there. He will move out. He does want the opportunity for his family members. He won't go there himself, to go there to remove the personal property that he still has there. Given my client's history, Your Honor, and the fact that he has gotten to the age of 38 without having been involved in anything like this, I would ask the court to consider giving him a signature bond. I believe he is recommended, and he would be a good candidate for that, Your Honor. He indicates that he will comply with whatever conditions the court imposes with regard to any bond that is given to him. Nothing further, Your Honor.
All right. Defendant will receive a $3,500 signature bond through pretrial. Defendant is to take the one-day anger awareness course, have no contact with Mr. Crawford, and stay away from that location. He or his family members can return with law enforcement to get any items that might be at that location. And he's to have no alcohol, drugs, or weapons. Is there anything further?
Nothing
Judge,
further,
Holly.
Your Honor.
All right. Best of luck.
Thank you, Your Honor.
All right. Who do we have next?
Position 11, McNeil. You done?
All right. Good afternoon. Your case number is 22 CR 008435. 8453E, in which you're charged with theft by receiving or fair evasion and stolen property, which is the offense with the offense date of December the 21st. Do you understand your rights?
Yes, ma'am.
All right. As this is first arrest, we will go straight to Mr. Walker.
Okay, Your Honor. In this case, the defendant was arrested for fair evasion, and he also, when he was detained, a firearm was discovered which had previously been reported stolen. The state in this case is asking for a $20,000 surety bond, a $19,500 surety bond on the theft by taking or on a theft charge, and a $500 surety bond on the fair evasion.
Okay. The way it's written on the calendar, it's written. Okay, so it should be theft by. Okay, I've got it. All right, Miss Kim.
Yes, Your Honor. Mr. McNeil is 19 years old, Your Honor, and he was really excited to start his job this coming right after Christmas at the airport because he has an offer to start the job. He worked at Church's Chicken as a cook for the last 3 months, and he also worked for family business doing grass cutting and cleaning after he graduated from military school about 2 years ago. He actually dreams to have his own clothing / some kind of business shop soon. However, he is here because of fair evasion. We would like to request for signature on bond for fair evasion. And if Your Honor, please give him a signature on bond, even for stolen property. I don't think my client knew that was stolen. And Your Honor, this is his first offense. And yeah, he dreams to go to college soon in mid-20s. So I think this is something that he can, he'd rather have his dream pursued than being stuck in a jail for a long time, Your Honor. Thanks.
All right,
Your Honor, I just had a second chance of reviewing the warrant. I don't know if the defendant thought he was still in the Army, but apparently he had a .40 caliber Smith & Wesson with a laser attached to it. So the state has grave concern for the citizens of Fulton County. So again, we are requesting that surety bond.
All right, defendant's gonna receive a $15,000 split bond, $1,000 for the fair evasion. That'll be a signature bond through the jail, and a $14,000 surety bond for the theft by receiving. He's to have no alcohol, drugs, or weapons, including the subject weapon. That must be immediately surrendered. All right, is there anything further?
Nothing further, Your Honor.
Is that 14,000 through the jail as well?
No, 14,000 surety.
Surety, okay.
I apologize if I said signature. 14,000 surety.
So it's a split bond, okay.
Yes. All right. Best of luck to you, Mr. McNeil. Who do we have next?
You got a signature bond for the first charge.
Do we have a stay away on this?
I don't believe so.
I'm gonna ask for to remain compliant with all MARTA suspensions.
Yeah,
Okay.
if he's banned from MARTA, he must comply, otherwise, no stay away.
I will comply.
You can ask a question, but the best thing to do is to speak to Ms. Kim.
Yes, I'll
don't
call you so
interfere.
that way you can, I can explain everything to you.
Huh? Can you say that again, Ms. Cam?
I will give you a call so I can explain and you can answer me all the, you can ask me questions,
Okay.
okay?
Judge, the signature bond was to the jail.
For charge number 1, yes.
All right, you done. Position 12, Peppers.
What happened? I can go sound like this.
All right, good afternoon, Ms. Peppers. Your case number is 22 CR 0084556D, and which you're charged with loitering and prowling with the offense date of December the 21st. You understand your rights?
Yes, ma'am.
Mr. Howard?
You got over 40 total. We got 41 out of Florida alone.
Okay, so last 5 years.
Well, last arrest was November 1st out of LJ for suspended license. June 2021, misdemeanor possession of marijuana, possession of drug-related objects. That's all for the Georgia history. I got a 2021 petty theft out of Florida. What else? Resisting an officer without violence 2020. Trespass 2020. Another trespass 2020. Possession of cocaine 2018. 2017 possession of cocaine. 2017 petty theft. Want me to keep going?
No, that's good,
No,
Mr.
that's
Howard.
sufficient. That's sufficient. Mr.
The
Walker?
state is asking for $1,000 good bond and stay away from the incident location, which is 1155 La Vista Road, unit 2234. It appears that the defendant was squatting in a vacant apartment at that apartment complex. He had previously been criminally trespassed from that property. Based upon the history and based upon the previous criminal trespass at this exact same location, we feel as though $1,000 surety bond is more than reasonable.
All right, thank you. Ms. Kim?
Yes, Your Honor, Mr. Peppers is 40 years old and he has been here in Georgia for about 1 year. He's from Florida and his auntie is residing here in Georgia. That's why he came here. He works at labor staffing as a temporary job. He does odd jobs and he's going to be qualified for public defender service since his income is not high enough. And Your Honor, actually, he is residentially challenged. So I will be referring social worker services to have a visit to give him a housing resources. And he said that there was another lady who was actually inviting him over to that place. So he was kind of confused when he was arrested. We would like to request for signature on bond for this case. Thanks, Your Honor.
All right, I'm gonna accept the state's recommendation. Defendant's gonna receive $1,000 surety bond. He is to stay away from the incident location on La Vista Road and have no alcohol, drugs, or weapons.
I have a question. Is it La Vista Road or La Vista Walk?
It may be La Vista Walk. Let me double check. It's La Vista Road / walk. I don't.
Okay.
Either way, he knows where he was arrested.
Okay.
Not to return.
All
I
right,
got you.
don't go back there, Mr. Peppers, either road or walk.
I never been there. That was my first time of going there.
Wait, don't say too much. I don't want the state to say anything that might be used against you, okay? All right, best of luck to you, Mr. Peppers. That concludes your case. Who do we have next?
Position 10, Lambert. You have to pay $100 to get out.
All right, good afternoon, Mr. Lambert. Your case is 22 CR 0084528. In this case, you're charged with 1 count DUI less safe, 1 count of failure to yield, 1 count of failure to obey the control signs, 1 count of 2 counts of hit and run, with the offense date of December the 21st. Do you understand your rights?
Yes, ma'am.
All right, Mr. Howard.
This is 10th arrest. On probation in Jackson County, harassing phone calls. Last arrest was back in September for DUI out of Johns Creek. 2021 DUI dismissed. Expired tag conviction from 2019. I got convictions for a sale of a Schedule 1 or 2 controlled substance, 2 counts. That was out of Gwinnett, 2013. Battery DV NOLO, 2009, 2008 DUI conviction. And the 07 DUI arrest out of Barrow County. It's not a disposition on that. That's all I got.
All right, thank you, Mr. Walker.
Yes, Your Honor, on December 21st of this year, I believe it was Roswell PD responded to an accident located on Upper Old Alabama Road. And upon speaking with the victim, they were advised that the victim, who was in a Silverado truck, was T-boned by another vehicle that left the scene. The victim was able to ascertain the defendant's license plate number. As upon researching who that vehicle belonged to, they went to the defendant's home. They were able to locate the vehicle. They were able to locate the defendant. The defendant did have bloodshot, glassy eyes. He did have a strong odor of alcoholic beverage. At that time, he was arrested for all of the above charges. Due to the defendant's criminal history, which includes previous DUIs, which some of them are still open, and narcotic convictions or arrest, we are asking for a $3,000 cash bond on the DUI, a $500 surety bond on the failure to yield, a $500 surety bond on the failure to obey. On the hit and run, we are asking for, let me read my notes, I'm sorry. We are asking for a $3,500 surety bond as well on the hit and run. Obviously, no drinking, no driving without a valid license. And that is all from the state.
Okay, I see 2 hit and runs, Mr. Walker. So are you asking 3,500 on each of those?
We could do a signature bond on the second count of hit and run if there's 2.
Okay, thank you. All right, Ms. Kim.
Yes, Mr. Lambert is 36 years old and he has been here in Georgia from 1999. He has his own business. He's a contractor at Roswell, Georgia, and he's not going to be qualified for public defender service. So my representation will end at the end of this bond hearing. And Your Honor, he has, we understanding the DUI charges in the past. We would like to request for $3,000 good bond instead of a cash bond, and also those driving offenses like failure to yield right away and failure to obey signs. We would like to ask for signature on bond for those 2, and also driving hit and run. We would like to request for $1,000 maximum good bond, Your Honor, totaling $4,000 good bond maximum. Thank you.
All right, one moment. All right, defendant is going to wait. Hold on. Okay, defendant is going to receive a $16,000 split bond as follows. It'll be a $10,000 surety bond on the DUI, a $500 signature bond on the failure to yield, a $500 signature bond on the failure to obey signs, a $2,000 surety on that first hit and run, and a $3,000 signature on the second hit and run. So that should equal that total of $16,000 split. He is not to drive without a valid license, and he's to have no alcohol, drugs, or weapons. Is there anything further?
Nothing further from defense. Thank you.
All right, best of luck to you, Mr. Lambert. What do we have next?
Position 4, Gates.
All right, good afternoon, Mr. Gates. Your case number is 22 CR 008444G. In this case, you're charged with criminal trespass with the offense date of December the 17th. Do you understand your rights?
Yes, ma'am.
All right, Mr. Howard.
He got 89 total.
Okay, last 5 years.
He was arrested last month in Riverdale, failed to appear. 2019, he was arrested on a capital offense that was dismissed. 2019, obstruction, criminal trespass. 2018, criminal trespass, criminal damage to property, 2nd degree. Another 2018 arrest, shoplifting. Another 2018 arrest for reckless conduct, conviction. Another 2018 arrest for trespass. 2018 was a bad year.
Okay, I
He
see.
got a lot more from 2018.
I think that's okay. I'm sure Ms. Sauer will give us the highlights. Ms. Sauer, please proceed.
Yes, Your Honor. Just to summarize that, in 2018, he was arrested for criminal trespass. I have at least 5 times, and he was convicted on those. This incident took place at Mini Mart Express, located at 1975 Campbellton Road in Atlanta. The defendant in this case was told to leave once he entered the store. As he walked out of the store, he picked up a stick and struck one of the doors, which caused the window to break, and then he fled the scene. Your Honor, we've heard all the criminal trespass convictions, so he does present a risk of reoffending, as well as the 2022 FTA, he presents a risk of flight. The state's recommendation is a $2,000 surety bond, a stay away from the incident location, and no drugs, alcohol, or weapons.
All right, Ms. Gant.
Thank you, Your Honor. Alvin Gates is 56 years old. He has been in the Atlanta, Georgia area for 14 years. He does have family here. However, he does not have anyone to assist with bond. Mr. Gates completed 10th grade. He is disabled, unable to work. He has been applying for disability for the past 2 years. However, he has never been approved. Therefore, he does not have any income at this time, Your Honor. We are denying the allegations. He's presumed innocent despite my client's history. I am requesting a signature bond on Mr. Gates' behalf. And if Your Honor determines that he's ineligible, then I would ask that bond remain as set at $1,000, and we are unopposed to any stay away conditions. Thank you, Your Honor.
All right, defendant or bond will remain as set at the $1,000 surety, and he's to stay away from the location on Campbellton Road, have no alcohol, drugs, or weapons.
Thank you, Your Honor.
All right, best of luck to you, Mr. Gates. Who do we have next?
Position 2, Dinwiddie.
All right, good afternoon. Your case number is 22 CR 0084447G. In this case, you're charged with simple battery family violence with the offense date of December the 21st. Do you understand your rights?
Yes.
All right, Mr. Howard.
22 total. Last arrest was back in 2020. FTA out of Douglas County. 2020 simple assault, obstruction, those are dismissed. Battery DV dead docket from 2019. Saw 2012 battery conviction. 2016 robbery, that was no bill. 2012 ag assault, battery DV. Oh, that was the battery, that was a conviction. It was a false imprisonment with that arrest as well. That was dismissed along with the ag. I got a disorderly conduct conviction from 2009. It was amended from ag assault. Simple battery dead docket 2008.
Okay, that's good. Thank you. Ms. Sauer.
Yes, Your Honor. This incident took place at 76 Stafford Street, Southwest in Atlanta. The victim in this case is the defendant's father, who is 75 years old. The defendant was upset with his father because the victim would not give him money to buy Christmas gifts. And when the defendant's uncle, who is a witness to this case, he is on the Zoom call. His name is spelled TheoPhilus, last name same as the defendant's. When the defendant's uncle left the house to go to the store, the defendant saw this as an opportunity to batter the victim. As the victim was laying in his bed, the defendant came inside and struck his 75-year-old father with closed fist, knocking him out of his bed. The victim did state he lost conscious for a while. When the witness returned from the store, he saw the victim lying on the floor in a disoriented state. This victim has stated to our office that he previously had a TPO filed against the defendant, so he will be seeking to file another one. As we've heard, the defendant does have multiple violent arrests in his history. I have all the arrests were against different victims, so he's essentially out there committing violence against multiple different people. It doesn't matter who it is or if it's his 75-year-old father. The state's recommendation in this case is a $5,000 surety bond, no contact with the victim or the witness, a stay away, and no drugs, alcohol, or weapons.
All right, thank you. Ms. Gant?
Yes, Your Honor. Mr. Greg Dinwiddie Jr. is 38 years old. He has been in the Atlanta, Georgia area his entire life. He states that he has 4 children. Mr. Dinwiddie completed high school. He is unable to work because of a traumatic brain injury. He is not receiving any income. He does not have the means to post anything toward bond. He is a resident at the incident location. However, given the state's position regarding the desire for contact, if we heard that, my client wants to continue having contact with his father. He states that he denies these allegations. He states that his father was in fact antagonizing him, and that he was merely defending himself. And we would just bring to the court's attention that this was an unwitnessed attack. I do acknowledge my client's history. However, again, Your Honor, he is presumed innocent. The last arrest that I see for violence is 2019, and that was dead docketed, Your Honor. I am requesting a signature bond on Mr. Dinwiddie's behalf. And if Your Honor determines that he's ineligible, then I would ask for the lowest bond possible, hopefully no more than $1,000. Again, my client wants contact, but I was unable to reach out to Mr. Greg Dinwiddie Sr. The number provided is disconnected. Therefore, we will defer to the court's ruling regarding the no contact and stay away orders. And if Your Honor orders my client to stay away, I would ask that he be granted a one-time law enforcement escort so that he may retrieve his belongings.
All right, defendant will receive a $3,500 surety bond. He's to have no contact with the alleged victim at this time, and he must stay away from the incident location. He can return one time with a member of law enforcement to get any items, and he's to have no alcohol, drugs, or weapons as a condition.
And Your Honor, the witness is on the call, the defendant's uncle. I'm not sure if he wanted to make a statement to the court.
I would hear from the victim only. I would not hear from the witness. I will sound for the victim. What is the victim's name?
Same name, Senior.
Okay. Is Gregory Bidwitty on the line and wishes to make a statement? All right. Hearing none, I'm not going to hear from the witness at this time. All right. Best of luck to you, sir. The bond will remain as set.
Thank you, Your Honor.
All right. Who do we have next?
Position 14, Global.
All right, good afternoon. Your case is 22 CR 008455F. In this case, you're charged with battery family violence with the offense date of August the 7th of 2022. Do you understand your rights?
Yes, ma'am.
All right, Mr. Howard.
8 total. Last arrest was back in November 2017. Simple battery DV, criminal trespass. The trespass was dismissed. They didn't list a disposition for the simple battery. Not sure why. Simple assault family violence, 2016 dismissed. 2010 probation, another 2010 probation. Came off a marijuana conviction, misdemeanor. 2009 obstruction, misdemeanor possession of marijuana, dismissed. 08 misdemeanor possession. He went to felony earlier for CWAC charge. He got no bond, so that's all.
Okay, thank you. All right, Mr. Walker, is this your case or is it Ms. Salary?
It's my case, Your Honor. The state is going to be asking for a $5,000 surety bond. No further contact with the victim, whose name is Marliza or Mary Liza, MaryLizza. Last name is spelled Mofford. A stay away from the incident location, which is 3751 Stephanie Drive Southwest. No weapons, drugs, or alcohol. On the day in question, law enforcement responded to the incident location. They spoke to the victim, Ms. Mofford, who advised that the defendant wrapped a t-shirt around his fist and began to punch her head into a wall and into a sofa. At the time, she advised the defendant picked up a kitchen knife and continued to threaten her. There was a third party that was present that was able to separate the two. At that time, the victim was able to escape to a different area in the home, and she did call 911, and law enforcement did arrive at the location, speaking with the victim and the defendant. The defendant was arrested on the battery family violence. Again, we are asking for a $5,000 surety with the previously mentioned conditions, and based upon the defendant's criminal history, we feel as though that those conditions and requests are more than reasonable.
I'm gonna sound for the alleged victim, last name Mofford or Mulford perhaps at this time.
And I'm sorry, I'm being told that the victim's name is Tasha Giles. I guess I had the witness
Okay.
and the victim swap.
Okay, sounding for Tasha Giles. All right, hearing none, Ms. McLeod.
Yes, Your Honor. My client is 34 years old. He is a native of Atlanta, Your Honor. He shares two children with the alleged victim, a 9-year-old and a 4-year-old. He has been fully involved in the lives of these two children. In fact, he tells me that he is the one who primarily takes them to and from school. And he has been doing this for a long time. He does not live with the alleged victim, Your Honor. He actually tells me that he lives with his grandmother. He does want to continue to have contact with these two children. So I would ask the court that any order that the court makes in this case take into consideration him being able to continue to interact fully with these two children. He does deny that he was the aggressor in this case. In fact, he says that they got into an argument and he decided, because he did not want the argument to escalate, to leave the scene, which is what he did. I do acknowledge that my client does have some history, Your Honor, but I maintain that his history is not significant, and it seems like the previous charge that he had involving family violence was dismissed. I would ask the court to consider giving him a signature bond, and if the court is disinclined to do so, a very low bond, because he tells me that he works doing gig sort of work, but he doesn't make a lot of money doing that. So I would ask the court to take that into consideration, and the fact that he does have to take care of his children also. Nothing further, Your Honor.
All right. Defendant will receive a $3,000 surety bond. He's to have no contact with the alleged victim. He can arrange to see his children by coordinating that through a third party. And he must stay away from the incident location on Stephanie Drive, have no alcohol, drugs, or weapons. Is there anything further?
Nothing further, Your Honor. And this does conclude my business before the court today. May I be excused?
Yes, you may. Take care.
Thank you.
Have a good holiday.
You too, Judge. Thank you.
Oh, all right.
Judge,
So-
I do have an announcement for position 3. It's gonna be a medical reset.
All right. And position 9 remains. Is courtroom 2 complete?
Yes, we're completed here in courtroom 2, Judge.
All right. Take care. Have a great afternoon.
Thank you. Happy holidays to you.
Happy holidays. Now I'm going to the South Annex. I'm assuming Miss Quan has not heard her rights.
No, Your Honor.
All right. Good afternoon, Miss Quan. I'm Judge Melanie Williams. This is the State Expedited Accusations Calendar. Your case number is 22 CR 0084468. In this case, you're charged with battery with the offense date of December the 20th. You have an absolute right to remain silent. Anything you say can and will be used against you. You also have the right to an attorney at this proceeding. This proceeding is being broadcast over the internet as a live stream. It's also being recorded. That means any member of the public can log on and access this. Do you understand that? Yes, no?
Yes.
All right, thank you. Mr. Howard?
6 total. Last arrest was last month. Suspended license, given false name out of Doraville. She was arrested in February, theft by receiving. That was DWAP. She don't have any violence. She just got driving stuff. DUI, driving without valid license. 2018 theft that was dismissed.
All
That's it.
right, thank you. Mr. Walker?
Yes, Your Honor, will be asking for a $3,000 surety bond. No further contact with the victim, whose name is Whitney Jones. Stay away from the incident location, which is 789 Ponce de Leon Avenue Northeast. No further drugs. No drugs, weapons, or alcohol. On the incident day, APD did respond to the Clearmont Lounge. They spoke to the victim, Ms. Whitney Jones. She advised that the defendant was in a restricted area. Upon speaking to the defendant, asking her to leave, the defendant became violent. She appeared to be intoxicated, under the influence. At that time, the defendant did bite the victim, leaving a visible mark. She was arrested by APD and charged with battery.
All right, thank you. Ms. Kim?
Yes, Your Honor. Ms. Quan is qualified since she is a single mother with a 3-year-old son who does not get any child support from the father of the child. And also her self-employment is very unstable, as she does photography and videography, and a lot of people want to save money. So nowadays her business has not been great. Your Honor, my client is 27 years old, and she was born and raised here in Georgia. She did graduate from high school, and Your Honor, she does not know the Whitney Jones at all. So we have no objection to stay away or no further contact. We will be fine with that. Indeed, my client was the one who was defending herself because they were attacking her, and my client was not drunken at the time. So we are very interested in actually watching the video to see what's gonna be showing in the video. We would like to request for a signature on bond, since this is her first violence offense that she has ever been arrested. Thanks, Your Honor.
All right, defendant will receive a $4,000 signature bond through pretrial services. She's to take the 1-day anger awareness course and have no contact with Ms. Jones. She must also stay away from the Clearmont Lounge and have no alcohol, drugs, or weapons. Is there anything further?
Nothing further, Your Honor. Thank you.
I believe that concludes the entire calendar.
Oh, yay.
If
That one
it-
is prejudice too. Just say.
All right, per judge. Ms. Bridgewater, will you please review the calendar for me?
Yes, but before we do, I need to get the breakdown on position number 1. I understand there is a total $4,000 good bond. So can we go through each charge so I can make sure I have the accurate amount on this bond order, starting with the driving defective or no headlights?
All right, that is a $250 surety bond.
Okay.
The
Number 2.
driving while license suspended, that's a $500 surety.
Okay.
The DUI is a $2,000 surety.
Uh-huh.
The giving false information is a $250 surety.
Okay.
And the open container is a $1,000 surety.
Okay, very good. Thank you. So once again, the reset date for the SAP calendar is going to be January the 5th. And of course, that's over in 2023, okay? Position number 2 is going to the SAP calendar with a $3,500 good bond. Position 3 is reset. Oh, you know what? We don't have court tomorrow. So Saturday, well, I need to find.
We have court on Saturday. I know.
Okay.
It'll
Well,
be
for those
reset
of
to
you-
Saturday.
Okay, for those of you who are coming back Christmas Eve, y'all will hear that case then, okay?
Okay.
All right, position 4 is reset to the SAP calendar with the $1,000 good bond. Position 5, I just had it. Hold on, I'll tell you. It is a $2,000 good bond, and it's reset to the SAP calendar. Position 6, SAP calendar with a $5,000 good bond. Position 7 is reset further notice with a $3,000 total SOB through pretrial. Position 8 is going to the SAP calendar with a $2,500 good bond. Position 9 is reset further notice with a $4,000 SOB through pretrial per judge. Position 10 is going to the SAP calendar with a $16,000 split bond. 11 SAP calendar with a $15,000 split bond. 12 is going to the SAP calendar with a $1,000 good bond. 13 reset further notice with a $3,500 SOB through pretrial per judge. And position 14 is going to the SAP calendar with a $3,000 good bond. Are there any questions, comments, or otherwise? With that being said, Merry Christmas, everybody. Happy holiday.
Merry Christmas.
All right.
holiday.
Yeah.
For some of you all on Saturday, I'm one of those who will be here.
Oh,
on Christmas
wow.
Eve. But everyone else, take care.
You
enjoy
get
your,
out in enough time so Santa can take care of those babies. And for everybody else with kids, make sure they're taken care of, okay?
All right.
Merry
You all
Christmas,
take care.
Tom.
Have a good holiday.
Happy
Merry
holiday.
Christmas, Miss Holiday.
Okay, thank you.
Take
Bye-bye.
care. Bye-bye. $2,000. Okay.